Kia ora tato, Nan Jensen here. I'm making this video because a lot of people are struggling with what happens when their child turns 16. They're being told, particularly by medical professionals, that they can no longer be involved in their child's care. The child has to sign everything, the child has to consent and make all the decisions. And so that is obviously creating a lot of stress, particularly for people whose 16-year-olds either unable to express that consent or to sign or to understand what's going on. So I just want to start with my disclaimer, which is that I'm just giving you information. This is not legal advice. If you need legal advice, you need to see a lawyer and you need to get a letter of engagement. But I think this kind of information could be really helpful for you if you do run into this kind of difficulty, which is getting more and more problematic for a lot of people. So look, the reason this is happening is because there was a new Privacy Act in 2020, and that act introduced all sorts of very serious penalties for breaches of the Privacy Act. And doctors and medical professionals are not lawyers, and they don't quite understand what this legislation is about. And of course, they're busy people, so they're mostly erring on the side of caution, but misunderstanding things. And this is making it really difficult for families because you can't get a power of attorney or welfare guardianship, property management, or administration until the person turns 18. So you can't do that in order to be able to act for your 16-year-old. So what we need to be able to explain to these professionals is actually, as a parent or guardian, you do have the authority to act on your child's behalf and to receive information about their medical care. So let me just explain to you how this works. Under the Privacy Act, there are pieces of subsidiary legislation. Well, there's subsidiary legislation under any act. And these are things that might be called rules, regulations, codes, directions, things like that, orders. So what we have here is the Health Information Privacy Code, which is a subsidiary piece of legislation. You can Google it and you'll be able to find a copy of the document. And it's important that you find this copy because this is what you might need if you have to go and argue with a medical professional about getting access to your child's information. So under this code, we have Rule 11, and Rule 11 talks about what a health agency must do and who they can disclose information to. And I'm sorry, I'm looking away from the camera because I want to read this to you. So Rule 11.1 says a health agency that holds health information must not disclose the information unless the agency believes on reasonable grounds, A, that the disclosure is to the individual concerned or the individual's representative, and the representative is where the individual is dead or unable to exercise their rights under these rules. Or B, it can be the disclosure can be authorized by the individual. So then we have to figure out, okay, it says it can go to the individual's representative, so then we need to know who's the individual's representative. Now, I need to point out that the word capacity, which we've talked about in our other videos, is not mentioned anywhere in this code. And capacity is a legal term, it's not a medical term. So then in the beginning of this code, in section 3, there are definitions of all different words, and one of the definitions is of the word representative. So the definition of a representative is, in B, it says, where the individual is under the age of 16 years, that individual's parent or guardian. And we already know that when your child is under 16, you are the guardian and you have the right to make decisions for them and to support their decision making. So then it says C, where the individual, not being an individual referred to previously, is unable to give their consent or authority or exercise their rights. So in other words, a person who may be lacking capacity, they would be unable to give their consent or exercise their rights. A person appearing to be lawfully acting on the individual's behalf in the individual's interests. So I'll read that again. The representative for a person who is not under 16, in other words, over 16, is a person appearing to be lawfully acting on the individual's behalf in the individual's interests. Okay, so when your child is 16, between 16 and 18, you are the guardian, you are lawfully acting on their behalf and in their interests, okay? So that's between 16 and 18. So that's where you need to bring this document and show it to them. If your child's over 18, then you're no longer lawfully acting on their behalf, and that's where you want to look at the videos about welfare guardianship or powers of attorney, because in order to act on somebody else's behalf lawfully, you would need to have one of those documents. Now, regardless of whether you're acting as an attorney or as a welfare guardian, you would still need to do supported decision making. So that means you would try to get them to act on their own behalf. You would try to help them make their own decision, help them understand the health information. But if you can't do that, then you have the legal authority to act on their behalf. So again, under 16, you are the guardian, you are the representative according to the rules in this code, the Health Information Privacy Code. So get yourself a copy online. After 18, you no longer are a legal representative, and therefore if you need to act on their behalf for some reason or have some sort of legal authority, then you do need to look at one of the other legal mechanisms such as power of attorney or welfare guardian, depending on whether they have the capacity to give you power of attorney. So watch my videos on those topics. I hope that was helpful. I feel like this video has been a long time coming. I've had a lot of people contact me about this problem. Kia ora, and see you in the next video.